I'm sure, as you know, we always wait just a few minutes to get all the stragglers in, but let's see, how are we doing on time? Oh, we're good. Yep, there are a few more people. All right, we'll get going. I am Judy Willett. I'm the Senior Project Manager for the Division of Palliative Care and Geriatric Medicine. And we are delighted this evening to be talking about holistic estate planning. Before we do that, I would like to make sure that everybody knows, which everybody probably does, but never hurts. Please use the chat function. Judy is going to be talking, Judy Flynn, our speaker, will be talking a lot about many details. So as it comes to you, if you have questions, suggestions, experiences, anything that you would like to have her comment on when we get to the Q&A, please make sure that you just go at the bottom of your screen. There's a little box and it says chat. Click on that and type in your question or thought, and it will go. Please don't put in any very specific personal things because everybody can see them, legal or medical. So make them general questions that everybody can relate to. The second thing that I'd like to tell you is that we are the Dementia Caregiver Support Program for the Dementia Care Collaborative at Mass General Hospital. We opened our doors, so to speak, in 2017. We are part of the Palliative Care and Geriatric Medicine Division. And as many of you know, the mission of our program is to truly transform memory care and provide services to educate, connect, and support patients, caregivers, clinicians, and everyone in the community to our services and dementia support. We offer care consultations to caregivers and patients from specific MGH clinics. We also offer skill classes for caregivers, fundamental skills, support groups, and health and resiliency programs monthly, along with this Conversations with Caregivers program. And we offer and are starting up again our Ageless Grace and strength exercise classes. So look online, watch for the flyers because that will be starting mid-August or the beginning of September. The Caregiver Support Program is largely funded through philanthropic support. So if you're interested in learning how to support our program, just you feel free to go on our website or get in touch with Chris White, who will be our moderator tonight, or with me. And let's see. Oh, I wanted to make sure that you knew that the foundations that support us are the Satter Foundation, the Bresky Foundation, and a new funder is the Berkshire Bank. So, but a lot, again, are from individuals. And we hope that you enjoyed this educational series, and I will pass it on to Chris White.
There we go. Probably helps if I unmute myself. So welcome everybody to Conversations with Caregivers. I am delighted tonight to introduce to you all Judy Flynn. Judy is an award-winning super lawyer, that's an official title, who operated her own practice until 2016 when she joined Falco & Associates practice down in Quincy. She is one of approximately 30 certified elder law attorneys in the state of Massachusetts and one of 6 elder law attorneys at the firm. All of whom represent older adults and people with disabilities and their families in all aspects of elder law and estate planning. A significant portion of the practice is devoted to assisting clients to obtain public benefits to provide the care and necessary to remain safely in the community or otherwise to cover nursing home care when necessary. Flynn served as the president of the Massachusetts Guardianship Association, the MGA, in 2010-2011, president of the National Academy of Elder Law Attorneys Massachusetts chapter, MassNALA, in 2014, and currently serves as vice president of the National Academy of Elder Law Attorneys, the national organization NALA. She currently serves also as co-chair of NALA's State Advocacy Committee, for which she has been doing so for several years, which connects NALA members and chapters across the country to collaborate in advocating for the rights of older adults and peoples with disability. And so again, it's with great pleasure that I introduce our speaker tonight, Judy Flynn. Welcome, Judy.
Thank you, Chris. Thank you, Judy. So what we're going to talk about tonight is holistic estate planning, a multidisciplinary approach. And what that means is elder law is special. It's about the client condition, care needs, that drives the plan. And so it's not transactional. It's not, here's your will and your power of attorney, best of luck. It really needs to be more relationship based. So what we do at Falcon Associates, again, we have the 6 elder law attorneys. We also have an ancillary business senior resource center where we have case managers. One of our attorneys is a nurse attorney, and benefits coordinators who do nothing but focus with MassHealth with the benefits application. So it's more of a holistic approach. So this presentation is, you're going to get the slides after the fact. So you don't have to write feverishly, and there's a lot of information here. I appreciate when I go to a presentation, I don't like to just get bullet points after the fact in case I miss something. So I've tried to really give a lot of information here. So the first part, we'll talk about laying the legal foundation. If you're part of the DCC, you might, someone you love may have a diagnosis of dementia or some other chronic condition. Care increases over time, typically with something like that. So it's important to lay the foundation with appropriate documents, with flexibility that are comprehensive to deal with whatever's coming down the road. But it goes beyond that with picking the right agents, people you can trust, etc. So I don't know if you're going to be putting up the slides at all, Chris, but okay. So we'll be talking about documents everybody should have. Healthcare proxies, HIPAA authorizations, durable powers of attorney. And we'll also talk about wills. How important are they? What's probate, avoiding probate, different types of trusts for various situations. Asset protection, which is a big deal. You hear these radio ads that are pretty scary. It's not right for everybody. And so I'll talk a bit about that. The next part of the program, we're going to talk about optimizing care dollars. So as care becomes needed, some private pay might be required, but we want you to know what kind of benefits are out there to make your dollars last longer. It might be VA dollars, it might be community MassHealth, there might be some Medicare limited coverage, long-term care insurance. Most people don't have it that come in our office, but every now and then somebody has a policy and it's wow. So we'll talk about all of those things. So laying the foundation, ensuring you have appropriate legal documents in place. First is the healthcare proxy. Everybody needs this. You're appointing
Judy,
a surrogate decision maker.
I'm sorry, Judy, this is also Judy Willett. Can you just tell me when you want me to move the?
Oh, I'm sorry.
That's okay. Thanks.
Yep. Go ahead, 2 pages. Perfect. So the healthcare proxy, you're appointing a surrogate decision maker, somebody that if you're declared incapacitated to make or communicate your own medical decisions, who's going to make those decisions for you? It's important. You're in control. By signing this document, you're still in control unless a doctor declares that you lack capacity. It's a springing power by law. That's what that means, that no authority is taken away from you until it's invoked and somebody that you've chosen is speaking on your behalf. It's important to have those decisions about what would you want in certain situations, because the job of the healthcare agent is to make the decision you would make in that moment if you could. So you have to have those important discussions. A HIPAA authorization is not a springing power, it's immediate. So if you're in the hospital, who can call and get information? How's mom doing? Usually people will include the spouse and all the children. Important decisions there. If somebody is disruptive or has issues that would, be of concern, maybe they don't get included in that. But that's part of a legal discussion. A living will. This is a written declaration of what you would want in life prolonging situations. It's not enforceable in Massachusetts. I think we're one of only a few states where it's not, but it can provide guidance for the healthcare agent you choose. It's traditionally been done by an attorney and is pretty generic, and I don't think it's very helpful. But if somebody comes in with one in place, don't tear it up. Just have those discussions. There are some more in-depth forms available, like through the ABA, the 5-situation living will, and things like that. Next slide, please. So what is, back one, back another. Yeah. So the MOST form, this is medical orders for life-sustaining treatment. This has taken the place of living wills in Massachusetts. It's not done with an attorney. It's done with your primary care physician or another provider. It's based on a discussion with your doctor, answering any questions. And this is fluid. It goes in your medical record and it can change over time. It's really an end of life document, but not just end of life. It could be based on age. I've had clients that didn't have a terminal condition that have a MOST in place, including do not resuscitates. It's up to you. That's a personal decision for each person to make. So the next is the durable power of attorney. And this is, in my opinion, one of the most important documents. This is you appointing an agent and maybe an alternate to stand in your shoes, do anything you could do with your finances or contractual issues, pay your bills if you're in the hospital. It's a powerful document. The one we do in elder law is very powerful. And the reason is because usually you may, if you appoint your daughter, for example, and she's trying to get care benefits at home for you down the road, she needs very specific powers in there. Including sometimes what we call a self-gifting power. And that's because you'll see later in this presentation that community MassHealth, sometimes we have to move assets out of your name, which is allowed under community MassHealth, to make you eligible for the benefit. That only makes sense if you have somebody you can trust to hold those funds out of your name. And if your attorney, in fact, under the power of attorney is taking that step for you, they need that specific power. That's just one example. There are two different ways to draft this. One is a springing power, which, similar to the healthcare proxy, springs into effect only when a doctor declares you're lacking capacity. I don't draft these. My firm doesn't do these springing powers. I think they're useless, frankly. Immediate powers grants your agent the immediate authority to assist you and act as your attorney in fact. If you can't trust the person you're naming to have that power immediately, then they should not be named at all. It all comes down to trust in this document. Any little voice in your head, you cannot ignore. It is a very powerful document. So we even run into clients call all the time that the bank is saying they can't use the immediate power of attorney. And we have to push back and cite to a specific clause and say, go back and push back, and it usually gets through. But if we had springing powers, it just puts another barrier between what needs to be done and getting it done. So immediate powers are the way to go, but you have to have full trust in whoever you name. A very important tip for anybody serving as the attorney in fact for the principal under a power of attorney is to never just sign your name. It's easy, you're writing a check or something and you're signing your name because it's easier. The correct way to sign on behalf of the principal is the principal's name by your name as attorney in fact or POA. That's making it clear you're signing as a fiduciary. This becomes very important when we're perhaps signing an admission agreement to a facility. because there's clauses in there that can sort of, I don't want to say trick you, but you don't want to inadvertently accept personal liability. So how the agent signs the power of attorney is very, very important. So what is probate? This is something that comes up frequently, and should you avoid it? Usually, yes, but some people think if I have a will, we have to file it, we have to go through probate. What determines whether somebody has to go, whether the estate has to go through probate or not, is if a person dies leaving assets in his or her name only. People avoid probate by adding joint owners, having named pay on death or transfer on death beneficiaries, or putting property in trust. Those things avoid probate. So other than those things, if people die with assets in their name only, the estate will have to be filed. It does not matter if someone has a will or not. That doesn't determine whether probate has to be filed. If the decedent, that's the person who died, if the decedent left a will, we call it testate. They died testate, and the probate assets through the court process will be distributed in accordance with the terms of the will. If the decedent died without a will, that's called intestate. And there's a statute in Massachusetts, probably every state, called the intestacy statute. And that spells out who gets what based on the bloodline or the family relationship. So in most cases, it makes sense to avoid probate. There's a cost and there's a delay of at least a few months to get probate through. So it's an expense you want to avoid. However, there's a couple of situations where it's valuable to go through probate. One of those is dysfunctional families. Sometimes court oversight is not the worst thing. And the other, and this is very valuable, is in a spousal nursing home MassHealth situation. We'll talk about that later, but there's a special type of will that we can protect assets immediately with no 5-year look back. Next slide, please. So there's a few types of wills that I'll focus on. A simple will, you're basically nominating who will be in charge of my estate. That's the personal representative. And your will spell out, this is how I want my estate distributed. My 3 children in equal shares, or their issue, meaning if any child predeceases, it will go down the bloodline to their children after payment of all valid expenses of the estate. That's very simple. Having that will does not mean you have to go through probate, but it's good to have a will even if you're titling assets to avoid probate. The second type of will we call a pour-over will. This is used when we have a probate avoidance plan. We might have a revocable family trust. We're titling assets to either into the trust now or to pass on death to the trust directly. And so the trust is the heart of the testamentary plan. Here's where I want my things to go. If something is missed, and say the person inherits and something has to go through the estate despite your best efforts, well, it just says pour it over to my trust, and it's going to pass in accordance with the terms in your trust. This next one, the will with testamentary trust, this is the one I just mentioned that is very valuable in a spousal, long-term, or nursing home MassHealth situation. When we have a married couple and one of them needs nursing home care or may need it soon, we might put the house in the healthier spouse's name to make it a probate asset, which sounds contrary. People try to avoid probate their whole lives. And then we tell them this is very valuable, and it's kind of confusing. Well, why would I do that? Because under the federal and state Medicaid regulations, assets that pass through probate to this specific type of Medicaid compliant trust created through the probate process are immediately non-countable. So it's a way to provide for the surviving spouse. The assets in that trust are for your spouse's sole benefit for his or her lifetime. But if the spouse ends up in the nursing home, those assets don't count. They are non-countable assets and don't get used for nursing home care. So on the death of the surviving spouse, those assets pass to your children or wherever you've designated they should go. So there's a lot of value to going through probate in that situation. And we do those special wills. My goodness, I'd say 90% of our clients. There's so much value. So let's talk about trust. A lot of times people come in saying, I need a trust, and someone said I need a trust, but they don't. What you have to understand, whether you need a trust depends on your situation, not what other people have done. And what are your goals? So a few types of trust we'll talk about. To avoid probate, you just need a revocable trust. That means you remain in full control. There's power in the trust that says, I can change my mind, I can revoke the trust, I can amend the trust. The trust is for your sole benefit for your lifetime, and then we'll pass outside of probate to your children or whoever your beneficiaries are. This keeps your affairs private. They're not in the probate court where things are public, and you avoid the cost and delay of probate. Next is an asset protection trust. This requires, well, one of the asset protection tools, if we're using a trust, it's an irrevocable trust. Irrevocable means there's no strings attached. You have no right to get the asset back. So let's say you transfer your house to an irrevocable trust. There might be some, this again would require an hour at least to just talk about this topic. But what I want to stress here, there's so many radio ads that are scary. You'll lose everything. You need an irrevocable trust. You have to understand that this is a big deal. It's not to be taken lightly. Irrevocable means irrevocable. And so when you hear something saying you can stay in full control, I'm sorry, I don't think that's true, because you're giving up the right to something. So the 5-year clock, that's kind of at the end, but if we want to protect assets from potential nursing home costs, you have to move them out of your name and get through a 5-year period. That's known as the 5-year look back. When you apply, if you applied, they'll look at the previous 5 years from that point. So when people do these types of trusts, they're putting a house or assets or an interest in a house in an irrevocable trust, and they don't have the legal right to get it back. Now, we do these trusts in certain cases for sure. It's a good strategy, but it's not something to take lightly. You have to have absolute 100% trust in whoever you work with, whether it's a child or somebody else. This is one case where I have to stress it's not for do-it-yourselfers. You need the guidance of an elder law attorney on this. It might be appropriate for you, it might not. And then there are other strategies such as a life estate deed to children, which presents its own issues. There are many different ways to protect assets, but this is just referring to the irrevocable trust. Next slide, please. So the next type of trust is called a spendthrift trust. This is something that's used when you have a beneficiary with issues like gambling, alcohol issues, other addictions, spending. You're sort of protecting your beneficiary from him or herself, because we don't know today what condition that person will be in down the road when they're due to inherit. So it's best to direct that share to a spendthrift trust, which gives your trustee a lot of flexibility. If the beneficiary is in a good place, doing well, they can get cash directly. If they're not doing so well and it would be detrimental to give them a windfall or cash, the trustee has the authority to say no. Trustee does not have the authority to distribute the assets other than what you've said. They're for the beneficiary's sole benefit for life, but the trustee can do what's right for the beneficiary and pay the bills that are appropriate. These trusts are typically not funded until you pass, so it would just direct a share of your estate to this beneficiary's STT, we call it. One thing to consider is when you're appointing a trustee, usually it's a family member, it might be a sibling of that child, and you have to keep in mind this can create hostility because your trustee child may have to say no, and that's not going to go over well. So we always have a provision to allow that trustee to get out if a professional trustee or an attorney or a tax person or somebody else could step in. So we try to maintain a good relationship. Next slide, please. This is really important. So if you have a beneficiary with special needs, they either are getting public benefits now or may be entitled. We can see that they may be entitled in the future. You may want to direct their share to a supplemental needs trust or an SNT. These are irrevocable, but again, typically not funded until you pass. And if I'm leaving my child's share to an SNT for her benefit, that's called a third-party funded SNT, we call it. It's not funded with the beneficiary's funds. Somebody else funded it, so there's no payback required to MassHealth for benefits paid. So usually, if that child came into an inheritance directly and they had public benefits to protect, they could fund their own supplemental needs trust. But in that case, that's called a first-party funded supplemental needs trust. And there does have to be a payback to MassHealth. So they're allowed to preserve the funds for their lifetime, but there is a payback required. These are important because this can enhance the quality of life and dignity of the beneficiary and maintain those benefits. And if it's a younger beneficiary, they may need, we don't know what their needs will be for many years to come. So these can be an important part of an estate plan. There are really strict requirements for distributions from the supplemental needs trust. So this is another area where it's really not a do-it-yourselfer. There should be legal guidance. Somebody should get legal guidance if they're a trustee. All right, next slide. Yay. All right, let's talk about optimizing care dollars. So we're going to get into sort of in-home care because we get a diagnosis of dementia, some other condition, Parkinson's, Alzheimer's, whatever. Typically, there will be increasing care needs over time. So part of you laying the foundation, getting the documents, you also want to look at how am I going to pay for this care? How am I going to maximize my care dollars? Make sure I can provide what I need. So number one is educate yourself on what's out there. So if you're 60 or older, I suggest that you reach out to your elder services. You can do an intake and assessment if you've got care needs. There's something called the state home care program. So even if you're over the income threshold, you might get a sliding scale depending on your finances. So, but they can provide maybe 6 to 8 hours a week without us getting any MassHealth benefits. These are the agencies that provide, homemakers, Meals on Wheels, PCAs. So be aware that those are available without Medicaid. If you're a veteran, a couple of things I want to point out. And this again could be a seminar in itself. But if you're a veteran, be aware that any veteran who's a patient of the VA is entitled, the VA medical system is entitled to some home care at no cost. It's not dependent on service-connected disability. What you have to do is sign up for the VA medical system, get assigned a PCP at the VA. They have to assess you. You don't have to give up your other doctors. You just have to get tied in with the VA as well. And if the PCP agrees that you need home care, they can order it. It's typically maybe 4 to 10 hours a week, and that's no cost. But we've seen it as high as 16 hours a week. Also be aware that there are other veterans benefits, federal, state, even local. Some towns have their own local benefits. So I suggest you visit with every town has a VSO, a veteran service officer, and they can give you information and let you know if you should be pursuing any other programs or what's available in your town. There's another benefit way beyond this hour that we have, the Veterans Aid and Attendance. That's a federal benefit that will pay for unreimbursed medical expenses for some veterans who meet certain service and other criteria. There are financial limits similar to the long-term MassHealth, but that is something that you could inquire of your local veterans agent. Now, be aware, there are a number of MassHealth programs that can provide in-home care. So we're going to go over some of those. Excuse me. So who can benefit from MassHealth? Community MassHealth. Frail elder, an elder who needs help with at least 2 of the 6 activities of daily living, they're outlined there. Bathing, dressing, transferring, meaning getting up and down from bed or a chair. Ambulation is the mobility, toileting and eating. Or disabled individuals. When we're applying for MassHealth benefits, the person has to have been deemed already disabled by Social Security. So either they're getting SSI or SDI, or they did at one point, or we have to file another piece of the application to have them deemed disabled by MassHealth, but the disability would be a requirement for some of these programs. Next is some of the programs that we're talking about. So Community Choices is also known as the Frail Elder Waiver. This is through the ASAP, the Area Service Access, Aging Services Access Point. This is like South Shore Elder Services, you know, there's several of them across the state. This is paid for by MassHealth standard, and this has the strict income limit we'll talk about of $2,742 a month, gross monthly income, that's our threshold. The PCA program is when you're hiring individuals on your own, but the state will pay them. You can't hire from an agency. Adult children or any other person can be paid except for the spouse, who's probably doing the most, but that's the way it is. So Common Health and MassHealth will both provide access to the PCA program. Wonderful program called PACE, stands for Program of All-Inclusive Care for the Elderly. This has the same financial rules as the Frail Elder Waiver, the income limit, and we'll get into that. You have to accept PACE providers. It's a great program in that you're not seeing several different doctors who aren't communicating, because they have a plan of care for every person who's enrolled. They're all talking to each other. Everything's under one roof at the PACE Center, the doctors, the therapists, a day health program. So it's a phenomenal program, and the goal of PACE is to keep you out of a nursing home. And I've had my own family in PACE, and I can't say enough about it. Adult foster care, again, is paid for by either the Frail Elder Waiver or Common Health. That's when you may be living with a child or with the caregiver, anybody but the spouse, parent, or legal guardian. And the other programs where the Common Health or the PCA, where the caregiver is being paid, that's taxable income. They will get a 1099. The adult foster care is a tax-free stipend, so that's a difference. And it really depends on what's right in each situation. It's a full assessment as to which program might work for this family. Let's see. So one thing I want to highlight, we mentioned MassNALA, National Academy of Elder Law Attorneys, the Mass chapter. There is a bill that we have put forth several legislative sessions now. There's a disparity, go back. There's a disparity under PACE. So if your income is over the 2742 gross monthly income, you have to spend down to 542 a month, which if you're living in your home and your real estate taxes and medicine and groceries, who can survive on that? But if my income is 2742 or less, I keep my entire income and I get all the benefits of PACE. So it's a real disparity. So instead of having to spend down when you have excess above that 2742, our legislation says just let people pay the excess as a monthly premium. So if I'm at 2743 a month, $1 over, I would have to pay thousands of dollars as a deductible before I could get these benefits. Our legislation says, just let me pay $1 a month, the excess, and now we're all on a level playing field. So that's the type of good work, if I can give a plug as far as what MassNALA and NALA does. So, all right. Let's go. Okay, you're way ahead of me, Judy. Perfect. These are some of the benefits we're talking about that can be covered by these MassHealth programs. Home health aides or personal care attendants, people to help you with your personal physical care needs. Adult day health, respite for the caregiver at home, change of scenery for the person needing care, transportation to and from the adult day health. Adult foster care, that's one of the options is caregiver homes. We talked about that when you're living with the caregiver, that's that tax-free stipend. PACE, we just talked about a little bit. These benefits also pay deductibles not covered by your primary insurance or Medicare. And a Lifeline type device is paid for, and there's help with prescriptions. Medicaid will pay your Medicare D premiums, and the copays are something like $2 to $6. So there's some pretty phenomenal benefits here. Next slide. So getting a little deeper with the requirements for the frail elder waiver, this is where you're getting the help through the ASAP, that area aging, the local elder services, have to be 60 years of age or older. It's also known as home and community-based waiver. What the waiver does is it allows a disregard of the spouse's income. It allows the sick spouse to have $27.42 in income. No waiver is needed if the income is $12.15 or less a month, however. And I don't see that often, but every now and then it comes up and we don't even need to get the waiver from the elder services. That waiver, by the way, is provided by the elder services. They send a nurse out to do an assessment, and they're going to decide, once it's approved, how many hours will be awarded, how many hours of PCA coverage, or how many days at the adult day health. So it's a really valuable benefit to keep people in the community. If it's an individual who's applying, they can only have $2,000 or less in countable assets. If they're married, the healthier spouse, the well spouse, can have about $148,000. Now, if they have excess assets, we can transfer them out of, first of all, interspousal transfers are always allowed. So the one who's applying, you move the assets into the healthier spouse's name, that's allowed. And then under Community MassHealth, we can take the excess assets, move them to a child you trust or somebody else. Now, again, that's a big deal. You have to fully trust whoever you're working with on this, because if you're giving it to a child to get it out of your name, you can't really have an agreement saying, but you're just holding it for me. But you're trusting that they are, honestly, because you can't get the benefit until you move those assets out of your name. The house is non-countable, whether it's an individual or a married couple. There is a maximum equity exclusion of a little over $1 million, which sounds like a lot, but you know, if you're in Nantucket or on the South Shore, or there are homes that are over $1 million easily. So again, the key with this is transfers or gifts are allowed. Moving the assets out of your name, it's allowed under Community MassHealth. But I really can't stress this enough. You have to trust whoever you're working with, a child or whoever, because let's say you do this, you get the community benefit in place, but you decline in a year and you need a nursing home. That same transfer of assets out of your name to get the community benefit is a disqualifying transfer for the nursing home coverage. So you have to trust that the child or whoever you're working with is holding it somewhere in case you don't get through the 5 years, or holding it to supplement your needs since you had to get down to $2,000 or so. And this, look, this is a lot of information I'm throwing at you, but I want you to have some sort of overview, and we can get into more detail at the question and answer. Next slide. Oh, I'm sorry, stay there. Sorry. Another really important point. MassHealth has an automatic lien against your probate estate in Massachusetts. That means assets in your name only, they are first in line before your heirs. They can collect for any benefits they paid for you from age 55 on, or a nursing home at any age. Now, some states they can collect from non-probate assets, joint accounts, trust property. We're lucky in Massachusetts that they only collect from the probate estate because it's easy to avoid probate by having joint owners, named beneficiaries, or property in trust. MassHealth is not going to be able to collect. They can't lien those assets. All right, next slide. For real. All right, Common Health is another community MassHealth program. There's pros and cons as to which program we select. It's typically been for under 65 and disabled people, but we've learned we can also use it for over 65. It's limited. You cannot, Common Health, you can't hire from agencies, so you can't get help through the local elder services. You have to hire individuals. You cannot hire from an agency. That's tough, especially after COVID. It is hard to find the caregivers. Even the elder services are having trouble filling the need. So that's the downside of Common Health, that it's tough to find the caregivers yourself. But if we have somebody whose income is too high for the other programs, it's a blessing that at least there's something we can get. So this program is not accepted by waiver programs like the Elder Services, which is called Choices 2, the PACE program, brain injury program. But there's no income limit, no asset limit. There is a monthly premium that's based on income. So we also have to assess, is this worth it? It usually is. It might be $50 to $100 a month for a boatload of services. But sometimes when income is very high, we have to do that calculation and see that it's worth it, because the spouse's income is factored in as well. There is a one-time spend down based on income. This is going to sound crazy, but this is, I just tell you what the rules are. Unless we provide what's called the 10-hour working letter. And people look at us like we're crazy when we try to explain this, but we've been encouraged by MassHealth to use this. If we're going to go ahead a slide or two because I want to show this. Oh, the next slide. So there's a spend down unless we provide the 10-hour working letter. So you take your income minus the MassHealth allowance of $542 times 6 months, and that tells you what this one-time deductible is before they'll stop paying the benefit. Now, this is a very low example. When we have a higher income and a spouse's income factored in, we're talking about many thousands of dollars that they have to pay out of pocket before the benefit kicks in. Or let's go back. Or we can provide what's called the 10-hour working letter. Somebody other than the spouse issues a letter. It can be an adult child saying, I, Judy, pay my mother $1 an hour for 10 hours a week to water my plants, to read to my child, to mind my cat. It has to be something they could actually do. But once we provide that letter, there's no further inquiry about this. Nobody checks. Nobody's saying that a $10 bill exchanged hands. It waives thousands of dollars. So I know it sounds crazy, but it's something to be aware of. Again, I have the caution here because Common Health is a Medicaid program. There's automatic estate recovery. So avoid probate, or MassHealth is first in line before your ears. Next slide. One more. Next slide.
Judy, are you with us?
Sorry, guys, I'm back.
Go ahead. All right. So these exceptions to that spend down that we just did, the deductible, is the 10-hour working letter, $1 an hour. That does the trick. Or if somebody, and I don't see this, I don't think I've ever seen this in my career, but if they've worked full time in the last 6 months, then became disabled, that's an exemption as well. Next slide. So this is just sort of a summary again of, let's see, so the under or over common health can be used for either no asset limit, no income threshold. There is a monthly premium based on income, including the spouse's income if married. 28 hours a week of care is an average that we see, and there's no penalty for transfers between spouses ever. And then on the other side, we have the MassHealth standard. You have to be 60 or over. Asset limit of $2,000 for the person who needs the care. Income limit of $2,742 gross monthly income. And the frail elder waiver would allow the spouse to retain assets up to about $148,000. Judy, you look like you're about to ask something. No? Okay. All right, next slide. We're zipping through this really fast. All right, so long-term MassHealth, which is for nursing home only. This is the benefit program that pays for nursing home care. The applicant can only have $2,000 in assets, countable assets in their name. The community spouse can have $148,620. The primary residence is non-countable up to that equity limit we talked about. And here's where there's a 5-year look back. So you're applying for this benefit. There's going to be a 5-year audit going back in time. And there's going to be a penalty for gifts you made, transfers you cannot document and verify. MassHealth doesn't like explanations. They want verification. So we don't live our lives keeping clear documentation of everything we do, but I'll tell you, if there's a diagnosis in the family or something like that, you have to start, you don't want to be doing a lot of cash withdrawals and cash transfers. You want to use an ATM card that shows point of sale. You want to keep receipts for anything that you're just paying, you know, Judy Flynn. They don't know that that's not a gift to Judy Flynn. So if you pay for a new roof, you want the invoice because you're going to be scrambling to get these things down the road. They can deny the application for failure to provide verifications they ask for. And it's a valid reason. So you have to get the verifications they want. So be aware of it now and make your life easier. There are, let's talk about, there's a couple of things we can do with excess countable assets. I don't know how deep I want to go into this, but in general, the house is non-countable. Our usual planning would be to deed the house to the community spouse and his or her name only with that special will we talked about. Because if the community spouse died suddenly before the nursing home spouse, we don't want that asset going right back and becoming countable. By setting it up with this special will with the testamentary trust, it's protected. It's there to supplement the quality of life, supplement whatever this nursing home spouse needs, but it's not countable and you maintain that Medicaid eligibility. If there are excess countable assets above that $148,000, we can convert those assets to an income stream for the community spouse with a Medicaid compliant annuity. I won't get into too much detail other than to say you would never do this other than to stop the bleeding of $15,000 a month private pay. It's something you only do in this crisis situation. There is something if there's an individual and we're applying for nursing home coverage and they didn't do any advanced planning, they have excess countable assets. Right now, we have a strategy called a pooled disability trust. There was a bad decision in Massachusetts not long ago that people 65 and older are not going to be able to fund these as of I think it's in March. I have to check March or April of next year. So we're still taking advantage of this now. You can take the excess assets, fund this trust account with a nonprofit. There's a handful of them in Massachusetts. They have a sub account. It's pooled with other people's accounts. That's why they call it a pooled trust. Person has to be deemed disabled. And those assets are not accountable for the nursing home. They can pay for extras for people in the nursing home. Clothing goes missing. They might need a chair car to go to a family function, a companion. It can enhance quality of life. It's wonderful. But we may lose the ability to do this for people who are 65 and over next year. So, let's see, next slide. There we go. So again, we're just highlighting for long-term or nursing home coverage for a married couple. You have your community spouse and your nursing home spouse. Those are the amounts they can keep in countable assets. The residence is non-countable. That could actually be under the nursing home spouses. It doesn't matter whose name it is. The nursing home spouse can have their name on the deed, but you don't want it on the deed at that point, because if the healthy spouse dies first, the nursing home spouse ends up with it and it's countable. An automobile doesn't count. And you can spend down on a prepaid funeral, itemized list of goods and services, paying for everything you need. You can also do what's called a burial savings account with $1,500. That's not listed here. Whole life, they don't count up to $1,500 of face value. Over that is factored into the amount you can keep, that $148,000. And term life insurance is exempt. You just want to make sure it's not going to be paid to the nursing home spouse if the community spouse passes first. In the middle here, you'll see exempt the income during lifetime. So MMMNA, this is called the minimum monthly maintenance needs allowance. You don't have to remember that. This is an amount that the community spouse would need to live on. There's a minimum amount and a maximum amount. So if my income is, if I'm the community spouse and my income is only $1,000 a month, I'm going to be allowed a deduction from my spouse's income to bring me up at least to that minimum of $2288.75 a month. So that's sort of a minimum amount to maintain the community spouse in the community. It's based on some actual numbers plugged into a formula, but I think you get the gist. Let's go to the next slide. And this is for an individual, a summary of what are the rules for an individual who needs nursing home MassHealth. The primary residence is countable at that point, and MassHealth could say, well, you have to put it on the market, or you can convert it to rental property so long as it makes a profit. MassHealth will lien the property in that case, but you are reducing the cost of care from private pay to whatever the estate recovery is. And the estate recovery, once we get someone on MassHealth, they're not paying $15,000 a month, whatever the private pay is, they're paying maybe 60% of that. And so you're reducing the cost of care by allowing them to place a lien on the property. The other thing you can do is agree to sell the property if there's no desire to keep it in the family. And that buys us up to 9 months to list it and get it sold. And then there's a whole process I won't go into now with notifying MassHealth of when that sale takes place, but it's a way to get immediate eligibility without the house being a hindrance. Despite the house being there, it makes it exempt for up to 9 months, and you can get the immediate eligibility. I don't agree with this number on my own slide. I don't think the automobile has this magic number of 4,500, but so ignore that for now. You can reach out if you really have that situation. I don't think that's the case. Life insurance under $1,500, if it's an individual, is non-countable. Prepaid funeral, burial savings account, and tools of your trade, which if it's just an individual, I don't know what that would be. Countable assets, savings, retirement, stocks and bonds, investment property. So the primary residence doesn't count, but investment property, a second house, different ballgame. In some states, IRAs and retirement accounts are not countable. Unfortunately, they are countable here. So sometimes people come in and they're certain they're not countable. It's because they're talking to somebody in another state, they count here. Now, there are exceptions when we can give assets, not just to the spouse, or we don't have to annuitize or whatever. If you have a caregiver child, a child who has resided with you for at least 2 years, and they have provided care without which you would have been in a nursing home sooner, we can provide proof that it's your child and proof from your doctor of the care they've provided, and you would be allowed to transfer the house to that caregiver child. That's an exemption. You can give the house or any assets to a disabled child. And we have to show proof of disability, which is typically they got SSI or SSDI. I think there have been a few cases where they've accepted some other disability, but usually they want it from Social Security. Excuse me, there's another exception. If you owned a property with a sibling and that sibling has lived in that house, you could do a sibling transfer. Excuse me. All right. Next steps. So this is an area of law, and I know I'm biased, but I think you really need to work with an elder law attorney on any of these things. The NALA website, you can search by zip code to find someone in your area. I'm also biased as to the CELA designation because I have that, but it was like a separate bar exam. You're really proving expertise and knowledge in elder law. So you can see on the NALA website attorneys that have CELA after their name. The firm, Falco & Associates, we offer a complimentary 1-hour consultation. If you were had these issues and wanted to do an assessment, we have you fill out an intake form that provides the intake we need to assess what programs might be right for you, etc. So feel free to do that. And I think that's it. No, the next. Yes, and just a reminder, as Judy said at the outset, the DCC is paid for with donations, and so please consider them if you're able. And we don't want to go to the last page. If they can't sleep some night, they can look at the last page. My bio.
All right. There we go.
Hey, that was right on the target for time.
Yeah, right on time. Fantastic. So thank you so much, Judy. That presentation was wonderful and very informative. So with the time that we have remaining, we have about a half an hour left. So I encourage everybody here, if you have a question or comment that you'd like to relay to Judy, please type it in the chat below, and I will read it and we will get your question answered. So just to kind of give some people some time to formulate their thoughts, I actually have one question that I was hoping to run by you, and maybe it's, a question that others might have as well. For those, in my line of work, what I often come across in working with families are, those who are operating in what's called the sort of Medicaid gap, where, it's in broad strokes, it's a circumstance where people find themselves, having worked a lot of their lives, have some, forms of savings, the financial, requirements for something like Medicaid and MassHealth, they don't qualify for that. They make too much money, but they are also not independently wealthy enough to just be able to afford, broad strokes, all the care that a person might need, for somebody caring for somebody with a dementia spectrum disease. So for those families that fall into that sort of, gap, do you have any recommendations or, or anything that you find helpful, in working in those cases?
Yeah, I mean, I know what you're saying, but I think if you look at what we just presented, there's a program for everybody. And there's challenges with them for sure, but I think it's a matter of piecing together a number of things. So, can we get any care from the VA? Can we get any of these MassHealth programs? Medicare, even, there might be some home care under certain circumstances. So, and we can typically restructure assets to maximize the benefits. So somebody may be over the threshold, make too much, as you say, or have too much. But in the community, we're allowed to move that. So the real challenge is, do we have somebody really trustworthy? And I actually forgot to go into, this is along those same lines. So let me talk about when someone comes in, we're going to look at all the different, to what you're asking, we're going to look at all the different options. And we can get the frail elder waiver, or we can get PACE if the income doesn't exceed 2742, or there's going to be this thousands of dollars spend down, or PACE, they have to spend down to 542 a month, which may not be enough to live on, right? So that's tough, but we can balance that with, could Common Health do it? There's no income or asset, but then we have to also assess what are the family dynamics? What does this person's support network look like? So Common Health, if somebody has a child or local support network, Common Health could work and can pay whoever those people are. Sometimes we have a child who's given up work or reduced hours or something, so at least there's some payment there. But what about that older person or disabled person who really doesn't have a local support network? Common Health isn't going to work because they have to find the caregivers and they have to manage them, and if somebody doesn't show up, what do you do? So it's really a matter of assessing the big picture. What are the family dynamics? What are the care needs now? What do we think are the anticipated care needs? Income, assets. There's just so much to it, but I think there are solutions. We just have to get full information and sort of make a plan. It might be like a puzzle where we piece together several things. That was kind of long-winded.
Yeah, well, it sounds very similar to what we do here as part of the Dementia Care Collaborative, talking with families, mobilizing systems of support, particularly after an initial diagnosis, which is sort of, the earlier the better. And particularly with these types of systems, with 5-year look backs, it makes it all the more critical to, talk with somebody like you, the sooner the better. Maya asked the question, how do these rules, and I'm not sure exactly which rules you're referring to, how do these rules generally apply to domestic partners providing care?
Yeah, so actually probably more to your advantage, because if you notice, in many cases, I said anybody but a spouse could be paid. If you're not married, you're not the spouse and you could be paid. But on the flip side, there are spousal protections built into the rules, especially nursing home coverage, and we can, interspousal transfers are always allowed, and then the community spouse can keep that $148,000 and can convert the excess assets, everything above that, into an income stream for the community spouse. So if you're not legally married, it's not going to work in MassHealth world. I've actually had a few different cases where at the last minute, these people have been partners for 40 years and I say, I really think you should get married. And we've tried on a couple occasions and the doctor wouldn't sign off. So it's really, MassHealth has not caught up with some other things in that area.
I encourage everybody to, if you have questions, please put them in the comments section. I just see Maya's currently. While we're waiting for that, I guess, on a more personal note, I'm curious, in your line of work in a day-to-day basis, what do you find to be the most challenging aspect of your work when we're trying to construct these supports and these legal mechanisms? Like, what do you find most challenging?
Oh boy, I don't know if I can narrow it down. Sometimes family dynamics can be a hindrance. It's a challenge for sure. Sometimes, I don't know, I think it's in elder law, it's really important to identify who your client is, because a lot of times we have the adult children involved or present. There has to be a private meeting. Sometimes that can be a challenge, and children might be a little offended why they have to step out and we need a bit of a private meeting, but it's critical, especially if you might have a diagnosis, and it doesn't mean somebody lacks capacity, as you know, it's just a diagnosis, but we have to do that in every case, no matter what. So that can be a challenge. It's not always welcome, but it's the way it has to be. Sometimes there's an issue with kids. They're not all on the same page, and our duty is to our clients, not the kids, but sometimes managing those dynamics can be a challenge.
Got it. Great. Thank you so much. No wrong answer for sure, but it's just curious and from your
Yeah.
personal experience. Chris asks, can you, as an eligible attorney, work with people who can't physically come into your office to sign legal documents?
Yes, we do it all the time. It goes with elder law. We go to clients who can't get to us. And having said that, to clients who can't get to us, not because the child's busy and doesn't want to take some time off work, but we go to nursing homes, assisted living facilities, homes. We would encourage if they're able to do the first meeting, the consult by Zoom, or Zoom is good because I think a face is good, but if they don't have the technology or somebody there who can help them with it, we figure it out. We could go to them.
So glad to hear that somebody still makes house calls in this day and age.
Yeah, I think a lot of us do. You have to. And I just mentioned assisted living. I just want to mention something that didn't come up. Assisted living is for the most part not paid for by MassHealth. So that's something to keep in mind. And that can be, back to your question about a challenge. Sometimes I may think clinically, it's too soon for a nursing home, not safe at home, assisted living is the right thing. Kind of need to get buy-in that we're going to use the assets for mom and dad, because assisted living is, nobody wants to go to a nursing home unless it's absolutely necessary.
All right. Mary Jane asks, is the community spouse's 401k countable if it's greater than 148K?
It's, the community spouse, yes. And that's part of the balance here. So let's say for nursing home coverage, let me break this down. So for community MassHealth, if we wanted the frail elder waiver and we have to be within that 148, the retirement account counts unless the spouse is still working and still contributing to it. And I've had cases where there were several retirement accounts from the past and one current one from the current employer. And we've had them consolidate them all into the current one, and it all becomes non-countable. So the key is it has to be an active retirement account that they're still working, still contributing. But let's say they're not, then it counts. If they, so we have to balance out, you need some liquid assets and part of your retirement account. They can either liquidate part or annuitize the excess part of the retirement account. But it is countable unless they're still working.
Gotcha. All right. And then let's see here. Pat asks, are there any advocacy efforts underway to allow payment to spouses who are providing care? Any legislation in the works on that end?
Not that I know of. Not that I know of, but on the flip side, there are spousal protections to allow that spouse to keep the assets and part of the income. So not a total loss, if that makes sense.
I believe it does. Pat, please correct me if I'm wrong. All right. Karen asks, I have been with my partner for 30 years and not married. I have cared for him as his caregiver since 2009. Who would I contact to see if I could get paid per month? I'm guessing it's sort of along the same question as, non-spousal caregiver. Who would they have to contact to get this process started?
So a couple of things I want to offer on this. What we do a lot is a care agreement, a written care agreement whether it's to a longtime partner or a child or somebody else that you're paying care for care. It's so down the road when we have to provide documentation for transfers for MassHealth, we have a written agreement that says this wasn't a gift. This was for these services that are outlined in this agreement. So that's one thing I think you should consider. And the other is if you wanted to call for a consult or find an elder law attorney in your area, this is something where I don't know if it would be elder services, or I don't know enough about your specific circumstances as to which program you would need to apply for. But my info is there if you want to give a call, we can get more information and I can give you some guidance.
All
Excuse
right.
me.
Judy actually has a question. Judy Willett. How do you work for trusts, etc., when someone is single and not a married couple? So this is just a single person coming in to establish a trust, I'm assuming. Judy, correct me if I'm wrong.
Yeah, so again, what type of trust, what's your goal? But an individual can have a trust just like a married person. I think the question is, what is the goal of the trust? What type of trust are we talking about? Do you want to elaborate or?
No, mostly it was just a lot of the examples in MassHealth, et cetera, were how it affects couples. So I'm assuming with your healthcare proxy, et cetera, you obviously are not choosing a spouse, you are then choosing a trusted member of your family, et cetera. So it was a general question.
Yeah, so choosing a healthcare agent, power of attorney, trustee, personal rep under the will, trust is the primary consideration. But an individual can do a trust, married people can. It's about knowing what your goal is for that, then we decide what type of trust and make sure we appoint the right people.
Gotcha. I actually have a question. We've been talking a lot about, when folks first come to you, one of the first things to establish is what is the system of care around them? What's the family situation, friends, social connections? This might be more on the rarer side, but sometimes in my line of work, I come across patients that are very truly isolated, meaning that there are no family, no friends, no significant social connections. And when we're talking about these documents like healthcare proxy, power of attorney, it's all about naming somebody that you trust. Well, what happens if somebody just doesn't have that person?
It's tough, and we see it more and more. Professionals can serve. We will play that role sometimes if there's nobody else. We've really encouraged the people, is there a niece, a nephew, someone you can trust? If not, we will do that. And there are other professionals that will as well, other attorneys and other professionals. It's not ideal, and you really have to follow up and talk to the person and understand their wishes, etc. And then let me just say if somebody really has nobody appropriate, the probate court is not the worst thing in the world. There are cases where that's the right option. Or if they have kids, but they're fighting and each one wants control. Court oversight isn't a bad thing in a case like that. Kind of off from your question, but.
Yeah, well, I think it's within the same vein. And I think another question that often comes to mind, and a scenario that I try to get families and patients to consider, they're sometimes resistant to getting these documentations done because of the implications of giving up freedoms, giving up a lot of what a person has worked for their entire life. But there are often cases, especially when we're talking about dementia, where there, a progressive lack of insight makes it challenging to get those documents done over the course of time. In your experience, do you often run into that scenario where a person, there hasn't been a capacity assessment, a person is unwilling to, complete the documents, but there is clear, evidence, I would say, of impairment? What do you say to the family? How do you navigate around that situation?
So we want to know that the person has at least a minimal level of capacity. They know the family members, et cetera, and we'll do our own assessment and try to explain the importance. And a lot of times that will do it, you know. And sometimes people express, you know, not wanting to do these things. I've heard that, you know, they feel like they're giving up control. And I try to explain, this is you exercising control, not giving up control. You're saying now that if I lose the ability, this is who I want to make my healthcare decisions or handle my finances or whatever. That's you exercising control. But I think there is a fear that they're giving up control by doing this. So I think it's how you present it, you know, make them feel better that it really is exercising control and taking control.
Yeah, couldn't have put it better myself. Chris asks a follow-up to his question before about seeing people who can't meet you physically. Do you guys go to the Nantucket?
Are you flying me there? Not typically. I have handled cases on Nantucket, but they haven't really required me to go there like for a document signing. I meet people in Falmouth sometimes, and we have a Hyannis office. So if somebody wanted to come over to Hyannis, we have a Hyannis office, which is just a boat ride from Nantucket. But otherwise, I would say check by zip code on the NALA site.
Or just, you know, pay for a private flight, you know, simple as that.
I'm down for that. I'll even take the ferry. Haven't been there in a while. It's beautiful.
I can imagine. All right. So Maya has a follow-up question. If you hire an individual PCA, not through an agency, so this is just an individual person, do you have to report what you pay on a 1099 or hire them as employee and pay them associated payroll tax?
So that's kind of a loaded question. It depends on, I think, the scope of the work, the amount of the hours, et cetera. And there's that's probably a case where I refer them to the CPA to get more specific guidance. I sort of stay in my lane and kick certain things to the tax professional, and would need more information. When it's extensive enough that we feel like they do have to hire a payroll agency, et cetera, we can give them referrals and resources to get that done. And we have done that for some clients.
Gotcha. All right. Dan asks, regarding end of life, where somebody with Alzheimer's is ruled incompetent or lacks capacity, does it help to have a written side document for the healthcare proxy outlining when one would like to have only palliative care and not continued medical treatment? Any other comments or advice on this?
Yeah, we discussed the most form. So this is all the more reason why people should take control and get these documents in place. They would be putting their own wishes in that form that's now in their medical record and provides guidance to the healthcare people. Other than that, if they have not done that proactively, they're relying on the healthcare agent to make the best decision. What would this person do if they could make the decision at this time?
Yeah. I would also say, just as a general recommendation regarding advanced care documents, you know, most forms, healthcare proxy power of attorneys, please make sure that those documents are uploaded into, you know, your loved one's chart. It saves so much time in the moment of a crisis, not having to worry about, you know, producing those documents on a physical basis. If, you know, if the care team can pull them up immediately, it makes it a whole lot easier. So many times I've worked with families where, you know, the question comes up or the conversation comes up about advanced care documentation. Response is, oh yeah, we have power of attorney complete, we have healthcare proxy. And I say, that's fantastic. I can't see it.
And that's a really great point. When we send out the binder with the copies of all of the estate planning documents, the cover letter says, be sure to give the healthcare proxy and HIPAA authorization to your primary care physician and any other providers you typically see. And I also give people the caution that they hand out healthcare proxies in some places like candy. Don't sign another one. It's revoking the one you just did with us. And when we have a family with some dynamics, if Mary takes mom to the doctor today, she might be listed. And if Johnny takes mom the next time, now you have these competing healthcare proxies. So get it in your record and leave it there if there's no reason to change.
Absolutely. Marty says, one thing to remember on the MOLS is that folks fill out those ahead of time before the Alzheimer's hits. The decisions may be different with that diagnosis.
And the most form is fluid. You make changes. You talk to your doctor, things have changed. Here's how I want to change my most.
And I think it's also important to recognize that most forms are really in the context if the person is unable to make the decision for themselves. So if those documents exist, but a person is still capable of making decision or is, conscious, that those forms don't get put into place, because the person is still able to speak for themselves.
That's right. Great point.
All right. And then Kathy, I guess, following up on Marty, I agree that Marty, and as the disease and other health issues progress, the patient can have different views, which they express in moments of clarity, which is an interesting point. We see a lot with Alzheimer's, there can be progressive decline, but there are these moments where, and I've heard it described to me as, someone sort of emerging from a fog.
Mm-hmm.
And having those moments of clarity and, particularly when, it's difficult to get the documents in place. I often say to families, like, if you see those moments of clarity, sometimes it's kind of a situation where you have to strike while the iron's hot.
Right.
It can be difficult and challenging, but, that's sort of the game. It's not a game, but it's, what we have to do in order to provide the best care for our loved ones.
That's right.
Does the PCP have a MOLS form? I can actually answer this. So most PCP offices have healthcare proxy forms and MOLS forms on hand. As Judy mentioned that, they sort of hand those documents out like candy in a lot of clinics, especially here at Mass General for sure.
Oh, sorry.
Yeah. Well, it's true because it's a conversation piece where I tell folks, it's like, if you don't have a healthcare proxy, just ask for one next time you see the PCP.
Yeah.
I think, from a certain perspective, I think it's one of the easier forms to get completed and, get out of the way. And at least that's, one area of decision making, addressed and taken care of.
Mm-hmm. Another thing we tell people that most may be appropriate for is do a cheat sheet. You can go online, you can print it out, you can try to fill it out as best you can, flag any questions you may have for the doctor so that it's pretty much filled out when you get there and you just having the doctor go over any questions.
Yep. Pat makes a comment. I consider the most forms most important in a first responder situation. I would agree. Sometimes families that I work with often have like sort of bug out bags, and included in that bug out bag is, copies of these documents to have on hand should an emergency arise. You want to have sort of redundancies in this area, have it in the chart, have it on hand, ready access if there is a higher risk of, medical treatment being utilized in an emergency situation.
Mm-hmm.
Dan comments, thanks to both Judy and Chris for the helpful response and comments. You are most certainly welcome, Dan. Chris says no CELAs on Nantucket. Area of opportunity.
I'm looking for office space tomorrow.
All right. But can you use a notary?
I don't know what they mean by that. Meaning,
Okay.
if I draft documents, can she go to a notary in Nantucket, or he or she? I don't know if Chris is female.
This sounds like a conversation that would best be had one-on-one. It sounds like there are a lot of specific questions or concerns. So Chris, I would encourage you, we will be sending out the presentation tonight with Judy's contact info. So I think this might be a perfect opportunity to reach out and see if you guys can collaborate and work together.
Okay. Happy to help.
Yep. Pat mentions you can also download the MOLS form from the state's website. I would also say that's the same for a healthcare proxy as well. There is a form that you can download online.
Right.
It does have to be witnessed, I believe. So you still have to take it into the medical office. Yeah, 2 witnesses.
2 witnesses.
So you can't just fill it out, have somebody sign it and be good to go. That would be absolute chaos. So, but yeah, the form you can get and complete online, and then once you're in the doctor's office, have it witnessed by 2 other representatives. Let's see. Marty says, thanks for this presentation. A lot to digest, but very helpful. I would agree. I may have missed this, but how do we get copies of the slides? They will be emailed to you. So be on the lookout. Same way you got the link for this presentation, they will be sent the same way. And Chris says thanks, and Karen says thanks, Judy and all, for this info, very helpful. So we are coming up on time. So I guess we could start wrapping up. So Judy, I want to thank you so much for your presentation and all your wonderful wealth of knowledge that you've provided us all today. I think this is certainly an area that I think necessitates a lot of education. There are a lot of resources, but oftentimes folks just it can be very confusing. And so I would encourage you all, if you have questions or concerns in this area, Judy is a fantastic super lawyer.
That doesn't come from me.
Yeah,
I thank
maybe.
you for the opportunity. You guys do great work. And I'm going to plug the donation link again. It's important. That's how you guys do what you do.
Yeah, it always helps, but in any case, so for those still here, like I said, we will be sending out the PowerPoint presentation to you all via email. So again, be on the lookout. We will also be sending evaluations for tonight's program. So we would very much appreciate if you could spare maybe 5 minutes or so to complete that evaluation and send it back to us. They are completely anonymous, and we always cherish your feedback and see how we can improve the program in our presentations like the one we have tonight. I would also just want to give a heads up for our next program, which is Health and Resiliency, which will be occurring on Tuesday, August 1st at 5:30. And that is the Health and Resiliency class for the Relax and Rejuvenate seminar with Emily Kessler. So it is, I believe it's guided meditation facilitated by Emily. And we hope that if you guys are into that sort of thing, you will join us for that. So again, links will be sent out for that particular group beforehand. So, keep your eyes peeled and glued to your email inbox. All right. Thank you all for joining us tonight. And also this recording will be going up on our website, hopefully within the next few weeks. So you can feel free to watch this back if you have any heart's desire to do so. And I hope everybody has a wonderful rest of your evening.
Thank you all. Thanks so much for having me.
Thank you so much for coming. Thank you.
Alrighty. Bye-bye.
Bye.